Welcome to the Southern Compliance Updates for June and July. All right, in Alabama, how exciting. Alabama finally doing things. So the article states, getting into the weeds, the latest of the Alabama medical cannabis program. Only 3 months, 90-ish days, until the Alabama Medical Cannabis Commission is scheduled to begin accepting applications for licensees. It was a year ago when this all started. The Alabama State Board of Medical Examiners, which issues rules for licensed practitioners and physicians, issued the final rules in March 2022. These rules related to the physician recommendation of medical cannabis. Specifically, they lay out the eligibility requirements for a licensed physician to obtain a permit that allows a physician to then recommend patients for medical cannabis use. Once a physician has a Alabama medical cannabis certification permit from the board, the physician must complete a number of steps with his or her patient before recommending that patient for medical cannabis use. The Alabama Department of Agriculture and Industries, tasked with issuing rules for cultivation activities, issued its proposed rules, medical cannabis cultivation, on May 17, 2022. This proposed rules outlines the requirements for cultivators in integrated facilities licensed by the RMCC in creating their individual operating plans. In other words, the ADAI ensures licenses are cultivating cannabis consistent with the operations plans they will be submitting to the AMC as part of the licensing process. The deadline for comment is July 12, 2022. And beginning September 1st, 2022, a person may apply for the commission for a license for an integrated facility or for a license as a cultivator, processor, secure transporter, state testing laboratory, or dispensary. Sources in the commission have told us that the commission anticipates issuing licenses in February 2023. Once licenses are issued, medical marijuana growers can begin growing, but because it takes 3 to 4 months for a crop to be ready for processing, medical cannabis dispensaries won't have product to sell until summer or fall of 2023. Here's some more additional information. So they call vertically integrated facilities integrated facilities. And there's really only a handful of licenses, so this is going to be really competitive. I believe the integrated facilities are only issuing like 12 of those licenses, so we'll see what happens. Also, the allowable products in Alabama are tablets, capsules, tinctures, gels, oils, and creams for topical use, suppositories, transdermal patches, nebulizers, liquid or oils for use in an inhaler. And products that are not allowed are raw plant material, products that could be smoked or vaped, and food products such as cookies or candies. Ridiculous. So super restrictive. And also, Alabama also has this ridiculous requirement that women have to take a pregnancy test to confirm that they are not pregnant before it's either receiving a recommendation or straight up before dispensing. I'm not 100% sure on that, but either way, it's absolutely absurd that they're going to enforce this requirement. So, Alabama for you, y'all. And we got another one out of Alabama. Public hearing set for medical cannabis regulations in Alabama. So the state is another step closer to having medical cannabis available for patients. The Alabama Medical Cannabis Commission, AMCC, released a draft of regulations for the medical cannabis industry, and the next step is a public hearing for feedback that will be held on Thursday, but not all the topics can be changed by the commission. The commission is finally in the weeds of building the new state agency. Nice pun there. Quote, licenses for cultivation, processing, integrated licenses for the whole deal, transportation, dispensaries, said John McMillan, the director of the commission. These topics and more are all outlined in 10 documents published on the commission's website, where they are also accepting feedback. And Delaware House upholds governor's marijuana legalization veto. So the Delaware House of Representatives, the first week of June, voted to uphold the governor's veto of a marijuana legalization bill, a disappointment for advocates that come on the same day that a rally was held outside the state house to push the overturn of the veto. The chamber failed to override Governor John Carney's action in a 2020 vote, with one member not voting. The bill had initially passed with 26 votes, more than the supermajority threshold needed to override a veto, though some members were evidently hesitant to contradict the governor, even though they support the reform as a matter of policy. Stand up. My goodness. Have a backbone. And in Florida, Truliev's unlawful background checks, $60,000 class action lawsuit settlement. The settlement benefits Trulieve applicants and employees who suffered from adverse employment action as a result of a background check obtained since September 17, 2017, who were not provided notice, a summary, or a copy of the report. According to the settlement website, there are around 1,000 eligible class members. Trulieve is a Florida-based cannabis dispensary that sells cannabis products from its own brand, because you have to in Florida. The company has numerous locations in Florida, but has also expanded into other legalized states such as California, Arizona, Connecticut, Pennsylvania, and Maryland. According to the class action lawsuit against the cannabis company, Trulieve violates federal law with its background check policies. Specifically, the company allegedly took adverse employment action against applicants and employees with providing these individuals with notices, summaries of the report, or copies of the report. Plaintiffs in the case argue that these background check policies violate the Fair Credit Reporting Act, FCRA. Under the FCRA, companies cannot take adverse action against applicants or employees without providing credit report information. Employees must provide information about which credit reporting company provided the report, along with notices along individual rights to dispute the report information or any additional free report. Trulieve allegedly fails to meet these requirements. Plaintiffs in the Trulieve FCRA class action lawsuit argue they owed compensation based on these violations. Trulieve has not admitted any wrongdoings under the FCRA, but agreed to pay $60,500 to resolve these claims. Under the terms of the settlement, class members can collect a cash payment. Payments will vary depending on the net settlement fund and the number of class members who file a claim. For example, if the net settlement fund is $50,000 and only 250 class members participate in the settlement, each claimant would receive a cash payment of $250. The deadline for exclusion and objections is July 18, 2022. The final approval hearing for Trulieve class action lawsuit settlement is scheduled for August 18, 2022. Class members are not required to attend the hearing, but may request to do so. In order to receive payment from the settlement, class members must submit a valid form by July 18, 2022. All right, and some Oklahoma updates. Oklahoma marijuana activists submit signatures to put legalization on November ballot. Oklahoma activists have submitted what they say are more than enough signatures to qualify a marijuana legalization initiative for the November ballot. The Oklahomians of Sensible Marijuana Laws, OSML, campaign announced on Tuesday that it had turned in over 164,000 signatures to the Secretary of State's office. They need 94,911 of the submissions to be valid in order to qualify for the proposed statutory amendment. The initiative would allow adults 21 and older in the state to possess and purchase up to an ounce of cannabis and grow a limited number of plants for personal use. The campaign, which is being backed by the National New Approach PAC, is one of two citizen efforts to put legalization on the ballot, with another one still in the process of signature gathering for its own pair of complementary initiatives. The other campaign, Oklahomans for Reasonable Cannabis Action, ORCA, tried to challenge the constitutionality of the competing measure on a single subjective basis, but the Supreme Court rejected the argument in April. In any case, OSML has pulled ahead and expects its measure to go before voters in November, following the resolution of any challenges submitted to the signatures during the 10-day period and the verification of the petitions by the Secretary of State's office. Officials there will notify the governor, who would then issue an election proclamation certifying the measure of the ballot. Not sure if adult use will help Oklahoma. It's just going to be more regulations, but you know, at least for the operators, because they're struggling. And another one in Oklahoma, update on OMA's moratorium start date for new growers, processors, and dispensary licenses. The moratorium on processing applications for new grower, processor, and dispensary licenses begin August 26th, not August 1st, as previously stated in communications from OMA. OMA made an error interpreting the effective date of House Bill 3208, the legislation creating the moratorium. The language in the bill states the moratorium begins August 1st, but the bill itself did not earn enough votes in the Oklahoma legislature to take effect until August 26th. The state has a 2/3 vote requirement for bills to take effect sooner than 90 days after adjournment. As a result, the moratorium cannot begin until the legislation takes effect. Quote, we made a mistake in interpreting the laws as written without taking the vote count into consideration, said OMA Executive Director Ardrea Berry. We're double checking every piece of legislation affecting OMA from the last legislative session to ensure that this won't be repeated. We hold ourselves to a high standard, and we fell short in this instance. We hope the transparency in our message today is evident that we take seriously the trust of Oklahomans placed in OMA. OMA will stop processing applications for new grower, processor, and dispensary license at 12:01, August 26, 2022. The other previously described details regarding the moratorium remains the same. Current growers, processors, and dispensaries are not affected and may apply to renew their license when it's time. The moratorium will expire August 1st, 2024, or earlier if the executive director determines all pending license reviews, inspections, or investigations are complete. Awesome. And my last update for you today is out of Washington, D.C. Medical cannabis patients 21 and over can self-certification guidance. So interesting. Talk about like another really big gray area that's just going down. I mean, we're talking about Minnesota and the Midwest. This is crazy, but I'm for it. Today, Mayor Muriel Bowser signed in law the Medical Marijuana Self-Certification Emergency Amendment Act of 2022. Effective immediately, D.C. residents who are at least 21 years of age or older may self-certify on their patient application submitted to ABRA, that they will only use cannabis purchased from a D.C. licensed dispensary for medical purposes in lieu of securing a recommendation from their healthcare provider. Qualifying D.C. residents may use the self-certification option by applying in person Monday through Friday, 8:30 a.m. to 4 p.m. Applicants are encouraged to submit an online application prior to their arrival to expedite processing. Hard copy applicants are available on site. Approved applicants will receive their physical and digital registration during their visit. ABRA is located at 2014th Street Northwest Suite 102A. Patient and caregiver registrations remain free of charge through August 18, 2022. Registrations issued through September 30th are valid for 2 years from the date of issuance. So interesting. So good for you, DC. And that is your compliance updates for June and July in the Southern region.